Hey guys, let's talk about a couple of developments in the Doe case against Marilyn Manson in New York. First, Manson's first move in the case is to take it to federal court. That's a pretty big deal. We'll go over that. And the second is just the Jane Doe status. So this case was filed in New York Supreme Court, and that's their trial level court, not a court of appeals. It's just how they name their courts up there. So there's nothing special about that. It's like a place where you would normally file a case like this. After a quick recusal by the first judge, and we don't know why, maybe he knew a party or was related to somebody or something like that, the next judge set a hearing for the decision on the anonymous filing. Now, anonymous filings can be appropriate. There's safety issues, harassment, sensitive stuff. And it's not just for the plaintiff. Sometimes defendants can do it too. They can ask to have things sealed and their name redacted and made into a Doe status. That can happen. But I guess I do question in this case, if you file as a Jane Doe for those kind of reasons, is it consistent if your attorney is engaging in a social media campaign directing attention to your case and against the defendant? To me, that doesn't seem consistent. If the idea is to shield her identity due to publicity and its negative effects, this activity seems contrary to that, don't you think? But I'm not the PR police. It's just my opinion. Everybody do what you want. Anyway, for the lawsuit itself, Manson has to be served with that lawsuit to be required to respond to it. And service can be by, different ways, a process server, a law enforcement official, whatever, there's different ways to do it. But just because you file the lawsuit doesn't mean you have to respond to it. The defendant has to be served with it. And also served with this order, show up for this hearing about this Jane Doe, where Manson can contest that. Manson, I would think, if he were doing that, would say, hey, wait a minute, they're out there having all these press conferences talking about me. If they really don't want publicity, this person who's already done interviews before wouldn't be involved in this kind of publicity campaign right now. So maybe they'll resist that at some point. I just don't know. Anyway, I wondered on the Manson Cases podcast and YouTube video earlier that if maybe all of us even saw this lawsuit before Manson did. Maybe that's true, maybe not, because we did see it when it was filed. And whether he'd been served. It appears he hasn't been served yet, but he's gone ahead and made his first move anyway. Manson's attorneys have filed a removal to federal court. So he has taken the case out of state court and put it into federal court. When you do this, and when you file that notice of removal in the state court no longer has jurisdiction. It's in federal court now. So this thing about the hearing, about the Jane Doe and stuff, that's off. The state court has nothing to do with this case anymore. You can get into federal court in civil cases in basically two ways. And the first is if the suit involves a federal question, say an alleged violation of a federal statute providing a remedy, like in a Bianco case where she alleged that she was trafficked in contravention of federal law. So this case doesn't have that, or at least not that I know of. The other is diversity jurisdiction, and that's when the case involves parties of different states. They have to be completely different states. You can't have two defendants and one of them's in the same state as a plaintiff. There has to be complete diversity on the different sides, and the defendant can't be a citizen of the state where the suit is filed, and then the amount in controversy exceeds $75,000. And kind of one idea behind this is you don't want somebody out in a local area with a local judge suing all kinds of out-of-state people and taking advantage of a system. So you can move those cases into federal court and then have a federally appointed judge do that. But they don't hear all these cases. They have to be over $75,000. And for this analysis, even though there's a lot of John Doe defendants, those are ignored for purposes of diversity jurisdiction analysis. But you have to have those factors, and you have to have them completely, and you have to demonstrate those to the court. So if all that's true, the case stays in federal court and proceeds like Smith, Line, and Bianco, although those were federal questions. So if there is diversity, the plaintiff could have elected originally to file the case in federal court. However, the defendants can remove it there as long as they have all these factors. But if any factor is missing in his citizenship or the amount or whatever, the court does not have jurisdiction, and they will remand the case back to state court. That happens one of two ways. First, a party obviously can file a motion to remand. They can resist this removal to federal court and say, hey, the defendant was wrong, that these two people are the citizens of the same states, or they haven't shown something they need to show, or they didn't show that the amount in controversy is enough. So they can resist it. Or the court can do it what's called sua sponte, which means the court just does it itself. The courts don't do a whole lot of things sua sponte, but they do some things that way. And this one is one of those. Diversity jurisdiction is supposed to be construed narrowly. They don't want to flood the court with a lot of cases if they don't need to. And if it turns out later the factors weren't there, the case is supposed to be remanded. That wastes everybody's time. And if the case gets dumped early on, the court has one less case to contend with and it lightens their load. So moving sua sponte does happen. In fact, it has happened at least several times that I saw just this morning in the court where Manson has removed this case to, the same federal court. They've looked at it themselves and said, oh, you missed this or you didn't do this, and thrown the case back to state court. When they do that, the state court will then have jurisdiction over the case again if that were to occur. So when I first looked at this case, I didn't expect the first move to be removing to federal court, and here's the reason. New York has a rule that prevents the plaintiffs from naming the amount of damages in a suit, generally speaking. Many states did this to stop kind of headline lawsuits like $10 million for coffee spill and that kind of thing. So they just basically say you allege that you met the jurisdictional amount of damages. We'll leave the other particular amount for later. So the suit doesn't say that she's seeking more than $75,000, and she's not supposed to have said that. Does she want more than that? Yeah, probably. But she doesn't say that, and that's by the rule. So this creates a problem for defendants who want to put the case in federal court because they don't have a document or a set of facts saying, I want more than $75,000 in terms of the complaint itself. And there are plenty of cases in New York federal court, the same one where Manson is going, that have been sent back to state court just because of this reason. The court has said in cases like that, hey, look, New York has a provision because they have this rule that you can't state the amount, that you can ask the plaintiff to declare the amount they want. And you should do that before coming over here to remove the case, because you can't show us how much they want, but it'd be easy for you to find out. And if they say, I want $2 million or even $100,000, there's your facts for diversity jurisdiction, file your removal. Get that and make your motion. Don't ask us to read the complaint along with you and imagine, yeah, boy, that does sound really bad. They probably do want more than $75,000, so we'll just go ahead and keep this case. Don't do that. Go get the facts first and then bring it to us. So in Manson's removal paperwork, he addresses this issue. He correctly notes the New York rule against pleading damages, and he also correctly notes that's not the only way to establish the jurisdictional amount of over $75,000. He even cites a case. But I read that case, and an issue with it is in that case, the plaintiff responded to the New York provision. Okay, so the defendant actually used the provision first like the court wants them to do. That's different here as far as I know with Manson, because he didn't say he did that. And the plaintiff said, I want $74,999, obviously trying to keep this case out of federal court. And the federal court said, listen, when the plaintiff says that amount and the defendant makes the case that, look, that wasn't directly calculated, a jury could come up slightly higher or lower, that shows us to a reasonable probability we're dealing with a case here that easily could be over $75,000. That fact, combined with the circumstances around it, there's jurisdiction. But the problem for Manson, at least as I see it, is the defendant in that case actually had gone to the plaintiff and said, tell me how much money you want according to the New York provisions to get this number. They didn't just bring it in on the lawsuit itself. The cases I saw on that were sent back down to state court. Now, if the federal court were to look at this and say, hey, listen, you didn't go get the amount, we're not going to try and tease it out of the complaint, even if you are, likely right. So we're sending this case back down to state court. If that happens, it's possible as a general rule that he can apply again once such facts are produced. So what he can't do is go back up to the federal court and say, man, look at that complaint again. Just look at it harder. I know you were wrong on that. You can't really appeal it like that. But if they say you don't have the facts and then you go to state court and you use a state court provision to get those facts, like this process for asking for damages or discovery or something like that, there are different ways to do it. The general rule is that you can then remove the case back to federal court as a second time for that. I didn't look it up specifically here in this court because it is just a general rule that can happen. And I think that would apply here likely. I didn't check it. So why go to federal court? Why not stay in state court and do some of the things that we talked about, like motions to dismiss, maybe resist this Jane Doe declaration? It just depends. You can be, judge shopping. Maybe you like how this judge thinks in federal court on cases you've seen on how they deal with cases like this. You'd rather be there than here. Sometimes in the past, I know it's been stricter litigation procedures that if you're, a high-powered defense firm and you want to hold the plaintiff's feet to the fire, then you want a court that's going to spend the available time that you need to hold them to the fire of strictly construing rules and making sure that all procedures are followed. Sometimes that's the case. Sometimes in federal court, they have the resources to pay closer attention to complex motions. If the state courts are overworked, sometimes issues that really require a lot of thinking and analyzing a lot of cases and staring up at the sky for a little while to figure out what's what, you don't get the attention you need because they have so much work to do. And in federal court, they have law clerks. And in my experience, at least in federal court, they take the intellectual issue of the motions very seriously, whereas sometimes in state court, if it's too complicated, you may not succeed just because the court doesn't have the time. Not that they're dumb, they just don't have the time to spend but so much time on your case. It can also be that even though the federal courts apply the substantive law of the state on state-based claims, they don't have their own federal common law for, tort or whatever. They apply their own procedural law. So how that plays out in your case can matter whether you want it in federal court. If you think there's something that the court views as procedural that's more favorable to you in federal court than state court, you might want it there for that reason. Maybe you just want to work that plaintiff some. So even if it comes back down again, they have to deal with it potentially. And it can be a lot of other reasons, whatever. We'll just have to see as things emerge. Anyway, that's what's happened. The case is now in federal court. Whether it stays there or not, we don't know. If it comes back down, whether it goes back up there or not, we don't know that either. We'll see what happens next. Thanks, bye.